In part five, privacy, we will wrap up with our discussion of appropriation. We'll talk about the other two torts, which are far less common, and then we'll talk about some other special rules and considerations for media practitioners when it comes to personal privacy. By way of review, we remember that there are only three elements to appropriation, which is the big tort, the scary one for media practitioners. That one would be the taking without payment or permission the image of someone else to be used for business purpose, for with the idea of enhancing sales or increasing sales, whether those sales in fact increase or not. What matters is the purpose. And we remember that there are two groups of plaintiffs. One group, and we know that when we're talking about commercial appropriation, there's a very large exception. The largest exception is whether the person is a celebrity or not a celebrity. Use of their images for any news related purpose is not a considered to be an appropriation for trade purposes, even though sometimes it really is an image of a famous person is chosen because it will increase sales. That's still not a commercial appropriation as long as the intent is to uh, accompany some type of newsworthy development. Of some degree of interest to you in this regard might be the ongoing and rather sudden change in how college athletes are being uh, dealt with when it comes to compensation. Um, the California passed a law, and immediately thereafterward, the NCAA, which regulates university athletics, um, decided that they would change how they deal with the fame of student athletes. Normally, or historically, the practice had been that when a athlete signed up to be on a university team, they signed away their right to profit from their image. Uh, when a person was an exceptionally good athlete and the university started selling jerseys with that athlete's number or putting that person's image on tickets or posters or things in order to publicize and sell tickets or whatever, the student athlete had absolutely no uh, compensation. They by private law had given up that right. Well, by statute in California and then by decision of the NCAA, uh, they use this thing called the Fair Pay to Play Act. Now, this is not about like everybody who signs a student athlete contract is going to get a check. Uh, the idea here is that if there's a really uh, banner player who brings a lot of attention and a lot of focus and sells a lot of products uh, while serving as also as a student athlete, that they are entitled to some profit from that, so that their image, when it's appropriated by the university or by some external force, can be compensated. It's very complicated as to how this might work. There have been congressional hearings in it as to whether there should be some kind of a federal standard uh, or whether individual schools are going to be able to make up their own rules about how to compensate their star athletes, especially for the money that is made based on products and services and endorsements by the student athletes. It's going to be really interesting to follow. It's probably going to take 4 or 5 years to flesh out and then probably be modified several times. But as long as we're talking about this idea of using somebody's name or likeness without their permission for a trade purpose, when it comes to athletes, college athletes, the rules are changing. They can no longer sign away that profit potential that belongs really to them from their celebrity and from their athletic skills. They can no longer sign that away to the university. They have to be compensated in some way for that. And the discussions are all over the place about how it's going to work and whether it's going to work. But it's in October of 2019, this decision was made that's going to really change college athletics in a major way going forward. Another rule that comes into play in commercial appropriation is less prominent, but it's something that a media practitioner needs to be aware of. It actually dates to a 1950s TV star named Hazel. The show was named Hazel. The star was named Booth. And the rule basically is that when the original use of a person's name or likeness is for news or by consent, and then its later use for promotion, it doesn't become an appropriation tort. And we can flesh this out with some examples, and maybe it'll be a little bit more understandable. Take, for instance, Mick Jagger of the Rolling Stones is on the cover of Rolling Stone magazine. He's interviewed and he's given his consent by being interviewed, and there's a story about him or whatever, even if he hasn't given consent, and the edition sells very well. And it either by permission or because of the news exception, that initial use of Mick Jagger's photo on the cover of Rolling Stone is not an appropriation. But suppose the circulation manager for Rolling Stone, looks back over the year and sees these were our best-selling issues, and the one with Mick Jagger on the cover was among them. So they go and create an ad or a billboard with the covers of those magazines and says, subscribe to Billboard. This is the kind of stories we have. Then there's no news exception. Then the use of Mick Jagger's image is purely commercial. It's purely for a business purpose of trying to sell subscriptions to the magazine. But under the Booth rule, even that secondary use, it continues to be an incidental use. And as long as it's not mocked up with like a bubble coming out of Mick Jagger's mouth saying, "Buy Rolling Stone," then because the initial use was either permissive or approved or not tortuous under the news exception, then the subsequent use of that is not going to be that way. Another example, perhaps a little easier to understand, is that Channel 3 gets a picture of somebody, celebrity or non-celebrity, saving a kitten from a drain, and it's very dramatic footage, and they use it on the news, and the person doesn't even know that the image was taken, and so they see their name and likeness or their likeness on television doing this heroic act, and again may not even know and may be embarrassed by it. And so they've got some damages. They've got the name of their likeness being taken. It's not actionable under the news exception, though, because this person was photographed or videoed rescuing this kitten from the drain. Well, that story turns out to be real popular, and the station's social media manager cribs it, uses it, and uses it as a promo. Stay tuned for news at 6 because we'll have this kind of story. These are the kind of stories to report, or takes that story and uses it on social media and says, tune in to our TV station because we do these great stories. Well, in that case, clearly the purpose is shifted from news to commercial. It's all about getting people to watch the television station. But under the Booth rule, even though the purpose changed from being under the news exception to a purely commercial use, it's still considered to be incidental under the Booth rule. I guess we ought to say something about photo releases, consent releases, model releases. Um, some folks believe in using these all the time. They constitute what we remember from back when we were talking about consent, an express waiver of privacy. They say we consent. And a person who is informed of what's happening and chooses not to move or say anything will be deemed to have consented. But generally, especially people engaging in commercial photo shoots or taking photos that they feel like or that would be used in a business setting, are very wise to get model releases signed that give consent. A couple of wrinkles that relate to consent forms is that the person who gives consent must have the capacity to give consent. The two groups that do not are deemed not to have legal capacity are minors and people who have been adjudged mentally ill. So let's say Frank takes a photo of some kids eating an ice cream cone or eating ice cream cones, and it's such a great photo that the ice cream parlor decides to buy it from Frank and use it in their advertising. But Frank has gotten model releases signed by all the kids. The problem there is that the kids don't have capacity, and the parents would have a cause of action for commercial appropriation of their children's name or likeness. Because, again, the law carves out special areas for people without capacity. There's another defense that's available if somebody's accused of commercial appropriation, and one is that the person was in the distant background um, and was really not recognizable. And the same kind of logic applies to what's called transformative use. There was an original image, but it was changed so much that the plaintiff was not recognizable. And we can kind of go back to this photo to illustrate that. You know, say this lady in the red jacket or the lady with the brown purse said, "Hey, that's me." As long as nobody recognized them, then that's incidental use, and they would not have a cause of action for commercial appropriation if this image were used in an advertisement for the water bottles. And if it were just used in a news article about the health benefits of jogging, the news exception is what would apply. But if it were used in an advertisement for the water bottles or the tennis shoes or whatever, then the people in the background, they're not recognizable. Nobody's going to look at that, and it's logical that they can't be embarrassed by it. If nobody knew who they were, then that would be not actionable under incidental use. The next thing we talk about a little bit is something that's very prevalent now, is clickbait, using photos of celebrities and other things, especially in digital spaces, to get clicks, to get people to go through all the layers, finding out which stars smoke, whether they're on screen or off. Well, as everybody knows, clickbait is nothing more than to get somebody to view ads that appear with the images that are posted along with it, usually images of celebrities. That gives rise to the question of, do these celebrities, or is this a commercial appropriation of them? And believe it or not, the general rule is that it's not considered a commercial appropriation. But you always take it through the elements. And did they take this celebrity's photo and without payment or permission? The answer is yes. Was it them? Well, clearly, yes. That was who it was. Did they do it for a business purpose? Yes. They're trying to get you to use the person's fame in order to also be able to display some ads that you might click on or accidentally click on. And is there an exception? And the answer so far is yes. The courts don't really, as we'll see in a minute, they don't like to get into deciding what the public wants to know or needs to know or cares to know. The news exception is interpreted very liberally. And so, because in this particular example, there might be some interest in finding out which celebrities smoke tobacco on screen and off, and so there is considered to be uh, newsworthy, and the news exception would apply, and say that using the celebrity's image without permission was okay. Okay, well that kind of wraps it up for appropriation and the little carve outs for appropriation. But remember about this tort more than anything else. It's one that's it's both easy and difficult to commit. Intuitively, you know that you can't take somebody's photo and use it in a business ad for a business purpose or an advertisement. I mean, suppose you walked into some restaurant and all of a sudden there's a big picture of you eating at that restaurant saying, our diners love it here. You might be embarrassed by that, and then you would need the person's permission in order to use their image for a business purpose. And you also know about the news exception, because you know that when you're at a sporting event or walking through the Grove or getting your car washed and somebody's doing a story or later appears in some publication, that there's you are deemed to have consented to your photo being taken when you're in a public place, and you have no cause of action as long as there's some news reason or ever how slight for using it. The only prohibition is to use your image to sell products. And for famous people, the same thing is true, except the fact that their damages are based differently. You know that if you're working for a store and they say, we need to really sell more donuts, that you can't go and just like get a picture of some famous person and Photoshop a couple of your employer's donuts into their hands and use that. I mean, you would never do that intuitively. And we've spent like 20 minutes talking about that. But again, these don't get all bollocksed up about this being law and being hard. A lot of this is just common sense. You should know you can't use a famous person's name or likeness, or even an individual's name or likeness, to sell product without them knowing it. But you know that people's pictures appear in famous people and non-famous people pictures appear and all the time in news coverages, and there's been no payment or permission to do that. Okay. The third tort is one that no ethical media practitioner would probably ever commit. Another one is kind of gained on common sense. Here, publication is not the matter. The matter is that the person has, in some situation where they have a very reasonable expectation of privacy, such as being in the shower, being in a hospital bed, being inside their home. And so how the information was obtained is the crucial element in this tort called intrusion or intrusion upon seclusion. The cases are fact driven, of course. All these are. Anything that can be seen or heard by anyone can't be claimed to be private. If you're sitting on your front steps eating a popsicle and somebody takes your picture, you have no privacy claim. If you're sitting on your sofa and somebody sticks a camera up to the window and takes a picture of you sitting on your sofa eating a popsicle, you're a lot more offended by that naturally. And intrusion cases, newsworthy doesn't apply at all because the damages are based on the offensiveness of the intrusion. So the key question in every one of these is, was there a reasonable expectation of privacy? Did the person who is the plaintiff, who is saying you invaded my personal privacy, were they in a situation where they had a reasonable expectation that they were out of the public? Um, we have to talk about paparazzi a little bit in this context, because the people who track and follow celebrities all the time have gone through different waves of discussion. After Princess Di was killed, there was a backlash, and people wanted laws against uh, stalking, which there are laws against stalking, which can be enforced. But as far as taking photos of celebrities or anybody else in a public place, uh, the law says if you're in public, you're in public. And if somebody takes a photo of anything that can be seen by anybody else, then there's no legal complication or legal problem that arises with that. This also has to do with our technology and our ability now to take photographs or videos. You know that the first thing that happens when anybody starts shouting or starts pushing or shoving is that everybody else starts pulling out their phones and starting videoing wrecks and traffic stops and fights. And of course, these are a big mover for social change too. And then early on, when the technology was first coming out, the police in some areas said that they wanted laws against recording arrests or traffic stops of citizens taking pictures in those cases. But the Department of Justice said, as you certainly realize now because it's so prevalent, that this is, if it's taking place in public, people can record it. That's not a problem legally. Um, and again, there are plenty of existing laws. If the police say get out of the way when they're trying to make an arrest, and the person is in fact in the way, then the person can be arrested. Failure to obey a lawful order of a police officer has nothing to do with privacy. Uh, there's another statute, misdemeanor statute, called interference with law enforcement. Or interference with first responders. And if you're blocking a fire truck that's trying to get to an emergency scene, or an ambulance, or the police from getting to a building or a situation or dealing with a situation, then you can be arrested. But that's not the same thing as when the police would say something like, "Stop taking photos." Stop taking photos when you're in a public place is never a lawful order. Um, there are some situations, even on campus here, where the police have said, stop taking pictures. Well, that's not a lawful order. And a person who wants to take pictures, whether the person is a journalist or a passerby or whatever, can certainly do so. The decisions and the law are very clear about this. Again, the idea is you don't get in the way of law enforcement officers doing their things, or first responders doing their things. That can result in arrest. But if what's taking place in public spaces, you just want to photograph it, there's no law that says that it cannot be done, or that there is any privacy matter that arises. In this same context, we have to talk about stealth. Using telephoto lenses, using hidden microphones, using mini cameras. Those raise a lot of legal and ethical questions. But generally, the rule is that if you can see it with your eyes without any enhancement, or with a slight telephoto lens or something like that, then if you're seeing what anybody else can see. And if you're seeing or hearing what anybody else can see or hear, then it's perfectly all right to record that. That's no privacy issues uh, um, uh, apply in that case. But you have to remember that people on juries generally don't like it when somebody's been sneaky. And we'll talk about this more in other contexts. But you don't like it when people are sneaky as it relates to you, and those same people, including you, might be on a jury someday. And when somebody's done something really sneaky and claims to have done no wrong, then that creates a problem. Of course, drone technology is advancing very rapidly. For journalists, they are very good tools. They can find truth. If a chemical company says it's not polluting, but it's the river, but their plant is like a half a mile or more out of eyeshot, and nobody can actually see from the highway whether they're dumping chemicals or not, is it legal to fly a drone over their property? For the purposes of finding the truth. But the same thing can be said about drones, is that they pose a danger. The drone can carry chemicals. A drone could be used to really seriously invade privacy. So the law is evolving. Right now, the rule is that for commercial use of a drone, a media person using a drone must have an FAA license to do so. It's not really difficult to obtain that license, but you must have to do it. Hobbyists, it's different. Hobbyists don't have to have a license and just have to follow the local safety-related rules. But their commercial users will need to have a license. Also, a person who just happens to own a drone and is contacted by a media organization or somebody else and asked to use the drone for a news purpose would have to be licensed. So really, when it comes to technology, the conventional rules apply, and they all relate to what we reasonably expect. As you probably heard all your life, it's a violation of federal law to open somebody else's mail. Point-to-point communication is thought of reasonably by society as private. Historically, telephone conversations took place by wired communications, and a person had to actually tap into the wires in order to overhear somebody's conversation. Well, when it comes to cell phones, they're different. A cell phone is actually a radio, and it broadcasts a signal through the atmosphere. We talked about it at the beginning. They can be used as tracking devices. A cell phone is different in terms of technology, but it's not different in terms of how people think about it. When you're on your phone, when I'm on my phone and I'm talking to somebody, I don't expect that anybody out there who happens to have a receiver that can pick up a cell phone signal is listening in on the call. So what the Electronics Communications Privacy Act does is makes intercepting cell phone calls the same thing as wiretapping, where you would be actually doing a physical act in order to get into the wires through which people's voices were going, because this is what people expect. This is what they're accustomed to. They don't feel like when they're talking on their cell phone that they're having a public conversation, even though the technology is that they are. And if you have the right type of receiver and whatever, it can actually record or pick up cell calls, because again, they're using the airwaves just like radio. And but the law speaks to people's expectations, and your expectation is that it's you talking to Frank, and you and Frank are having a conversation, and it's not a public conversation. So intrusion is really a difficult tort for anybody who's an ethical media practitioner to commit. And remember that the act is punished by society in the form of a tort and civil damages because it's really a bad act. It's a bad behavior. It's bad conduct. Um, there's some nice rules that the Society of Professional Journalists has, best practices rules that come out into play here. And I'm not going to read each one of them for you, but basically they say just make sure before you gain information or you dance on the edge of invading privacy with by some technological or other means that the boxes have been checked to make sure that you're on good ground. The last tort doesn't take much time to talk about. And courts have a really difficult time trying to determine what uh, nobody would be interested in. No legitimate interest. What does that mean? And again, we're in a situation where people uh, differ. One celebrity might have a child who's ADHD and do fundraisers and everything and disclose that, but another person, celebrity or non-celebrity, might think this is very private information, very private medical information. What the individual plaintiffs think, it doesn't matter. The court measures whether there's a legitimate public interest in this information being disclosed, and that sometimes is difficult to measure. And in libel law, publishment, uh, spreading it even to one individual, you could commit a libel by publishing to one person. But in privacy law, publish means put it out there for mass consumption. Uh, and of course, the rule is that a fact isn't private if it's ever been in public. Once something's in the public, it's in the public and it's there forever. And certainly if it's in a public record, even if the plaintiff doesn't even know about it. And passage of information never changes the nature of information. If it's ever been public, it stays public. It doesn't become private. In most situations, by passage of. An example would be take Alice, and she's running for mayor, and she strongly prefers that the fact that her grandfather served time in prison not be disclosed. But if the prison record's a public record, then disclosing it is not an invasion of privacy. It's an ethical question for a journalist to decide whether, or anybody else to decide whether to tell people, oh yeah, well, Alice, her grandfather was in prison. Well, you're making an ethical decision or moral decision on whether that's relevant or not. But the fact that it's not an invasion of privacy because the fact is that anybody who looked in a public record could have found out the same thing. There's some other considerations that we have to deal with here when it comes to sex crimes. Um, Attitudes about predation have changed. We saw a lot of new attitudes and new thinking about how people relate to each other in the Me Too movement. But in the old days, by statute in a lot of places, the victim IDs were protected. A person, it was illegal to report that a person had been made a complaint or been a victim of a sex crime, sexual battery, or rape. And what this did was reflect thinking was that a person, a victim, was somehow or another at fault or blameworthy or had something to do with it or shouldn't have been there or something like that. And this is because society has really been confused about what sex crimes are. And I think there's some clarity coming now, but for too long people thought that rape was a situation where people just like got carried away, or a person just got carried away. That's not, that's never been the law. It's never been true. Rape is a crime of violence. It's like, it's listed in the Mississippi Code as a capital crime, and the capital crimes are arson and murder and aggravated assault, or attempted murder and rape. It's not something where somebody just like had a lapse of judgment. It's a crime of pure violence. Now, the problem that comes in, of course, is that states that have legal bans on providing sex crime victim names are prior restraints. The statutes are telling people, and especially the media, that they cannot identify these people. Well, they're likely unconstitutional. The better laws uh, keep the agencies from disclosing this information, and if the information is not disclosed, then that's not a prior restraint, and it just says that the law enforcement or other agencies have to keep the identities confidential, and because they have that duty to keep it confidential, then don't do it. But actually, in common practice today, most media respect the wishes of the victim, because some victims wish to remain anonymous, some victims wish to speak out. You certainly saw this in the Me Too movement, uh, where people were more willing to speak out about inappropriate conduct, whether it was criminal conduct or just inappropriate conduct. Difficulties, of course, can occur. Not identifying a victim is not as easy as it sounds. Um, if a person, for instance, well, just what it says on the slide, an alert is issued for two missing children, um, and their names and descriptions, their photographs are published. They're found 2 days later, and the adult who kidnapped them is charged with criminal sex activities. Well, at that point, the victims have already been identified, and you can't really unidentify them. So that's just kind of a situation that arises. But certainly, the media would not suffer any penalty for publishing the alert with the names and descriptions, even if they were later found out that they wished to have anonymity because they were victims of a sex crime. And we'll talk about these statutes, which is probably the last area of privacy law. But black letter laws do exist at the federal and state level that provide for personal privacy of certain types of information. FERPA is the one that deals with educational rights. HIPAA deals with health, medical matters, and the Children's Online Privacy Act deals with protecting children from marketing intrusions. FERPA makes academic records private. They can cause sports writers some grief because they have to just say, Susan is not playing for the high school team this year, and they're not really allowed to have access to the fact that she, didn't make good enough grades to make the team or whatever. Academic records are private. Interestingly, FERPA does not create a right to sue the school. If a school or a professor discloses academic information in violation of FERPA, the institution is the penalty is that the institution would lose their federal funding, and their ability to participate in guaranteed student loans and a lot of other things. But the individual student whose academic records are wrongly disclosed would not be able to sue for damages. HIPAA is the big one in the medical arena. It says that people who provide health care are to take that very seriously, that they don't disclose any information about what a patient's being treated for. It's why when you go to the dentist now, the person comes out and says, Miss Smith, we're ready for you. It doesn't say, Miss Smith, we're ready for your root canal. Um, Disclosing that type of information is a violation of HIPAA. Note that it only applies to healthcare providers who do take it very seriously, because I think that the basic fine starts at $5,000 per incident. But if you break your leg and you tell me you broke your leg, or I see you broke your leg, and I tell my friends Marsha broke her leg, we're just talking about your health care. Well, the HIPAA doesn't apply to us. We can talk about somebody else's health all we want to, and their medical conditions all we want to. It's only healthcare providers who are not allowed to disclose it. Now, for both HIPAA and FERPA, directory type information may be disclosed unless there's notice from a person that they don't want it to be disclosed. I know we've been talking a long time, but bear with me here. It's perfectly all right for the University of Mississippi to list your name in a directory of students. It can list your major, it can list any social or other clubs that you've been in, or what honors you've received, making the dean's list or the chancellor's list. It's perfectly all right. They don't have to have a student's permission to give out that information. Similarly, a healthcare provider can say that a person has an appointment to see the clinician, or can issue statements that somebody's condition is critical or fair or stable. It's the details like grades and appendicitis that must be protected. All the other type of information is lumped into what's called directory information, and that type of information is not protected in terms of privacy by the statute. Both also must provide opt-out provisions that allow release of even directory information. So at some point when you go to see a doctor, or at some point when you enrolled in the university, you were provided with some document that you listed the people who could have information about you on, and that form also said somewhere or another had a block that could be checked that said, don't tell anybody anything. And if that block is checked, then if you call the hospital and say, can you tell me how Susie's doing? They say, we have no record of a patient named Susie. Or if you call the University of Mississippi and say, can you tell me whether Susie's on the chancellor's list? And they have to look at your form and say, well, we have no student named Susie. So both of them do allow complete blockout of information. The last statute that we talk about is the Children's Online Privacy Protection Agent, and this is of special interest to those of you who are engaged in marketing, because it says that it's a violation of federal law to harvest information, marketing information, or from under 13-year-olds. And to some extent, you can't direct market to people under 13. And some of this has to, there's some parallel restrictions on advertising in terms of targeting ads directly to young people or preteens. But COPPA is not about that. It's just about not doing research on preteens or direct marketing to preteens. And again, it can be very real. Here's YouTube that theoretically has a lot of good lawyers, but its parent company was subject to fines because there was marketing messages that were placed on YouTube that were directed to preteens. Okay, that's it for privacy.